Yeah, so greetings to everyone. It is great to be able to see everyone. It would have been even better to see you all in person. But then again, we probably wouldn't have had this varied gathering in person. But we do the best that we can. I think it was not so far away from here, about 3,000 years ago, that King Solomon said, "There's nothing new under the sun." I think he was talking about what we would know as the human condition, how we react to in the face of difficulties, and that's, you can put the word, my using the word difficulty to the current situation, maybe to my British upbringing. I think the one thing that is common to every period that humanity's ever gone through is that it leads to breakthroughs in human ingenuity, and that, of course, is right up our alley. We have here entrepreneurs, and we have patent attorneys, and everyone here is dealing with innovation in some sort. And in particular, obviously, we're looking at innovation in Israel, or innovation that wants to be in some way or another imported into Israel, or potentially joint ventures which might be set up with Israeli companies from companies overseas. But everything is using the vehicle of intellectual property. And in particular, we're talking about Israeli patents. The first thing I'd like to do is to keep admitting people coming in. But apart from that, what I'd like to is I'm going to share my screen again, and just give a brief introduction to ourselves, to our firm, and what we're going to be discussing during the next hour plus. So here we go. Okay, here we go. Screen share. And here we are. Right, so I'm just going to minimize that so that I can actually see my, okay, good. All right, so first of all, if I can get this to advance, yes, I can. Just a brief word about us being JMB Davis Ben David. We're an IP boutique, as you may see from our logo, which to anyone that is familiar with us, this is a new logo that we brought out to celebrate our 25 years so far in business, May this year. We view ourselves as an international practice. Over the years, we've built up relationships with well over 1,000 firms overseas, providing services on behalf of our clients in those countries and vice versa. And so we are definitely a truly international business. But what do? We do what you'd expect from any IP boutique. We do patents, we do trademarks. We don't make incredible pictures like this, such as I'm sure that most people are familiar with Escher. I'd like to be able to make pictures like that. I can't, but I can obtain them once in a while. We do designs, and we handle a certain amount of copyright. In Israel, there's no copyright registration, but there's obviously litigation. We're here to talk about patents. So in terms of what we do in patents, well, as you can see, it's pretty much everything. Any type of field that you can think of. We have people that handle these fields. You'll meet Evyatar in a couple of minutes. He's what I would call a tech geek. Evyatar, I hope that's okay if I describe you like that. Mike comes from the field of bio. Avram comes from the field of chemistry. An ex-Teva person. They'll both introduce themselves, and you'll get to hear them talk. I would just like to add that, as I mentioned in the emails that were sent out beforehand, if you would like to ask any questions, please feel free to do so. submit them using the chat, and we'll be able to have a session afterwards to handle these handle the questions. And these discussions afterwards are often the most enjoyable part of the proceedings. But anyway, so what do we have coming up? So first of all, I'm going to be giving an introduction as to who files in Israel. I will not be solving the mystery as to why people file in Israel. Is clearly very, very subjective, but we'll get into that in just a moment. After that, Evyatar is going to give an outline of the basic stages of the application process with a bonus. We had a question before during the week from Idan about AI. And when I spoke to Evyatar, he said, look, that's software. So Evyatar is going to relate briefly to how we claim software inventions. No surprises there, but nonetheless, even the obvious sometimes need to be stated. After that, what I'd like to call transatlantic bioclaims. Part of some of the tools that we're going to be discussing today, Avram will be discussing them, is the use of claims that have been allowed in other jurisdictions as a basis for gaining quick allowance in Israel. And not everything can necessarily be allowed in exactly the same format, and that's due to differences in law. And so Mike will be explaining how you take the, shall we say, the square bioclaims from a granted US patent and fit them into a round Israeli whole, which is defined by differences in law and therefore claims. Part of the most interesting part of this presentation is going to be given by Avram, controlling speed of examination. He has some neat slides, but even neater, even more interesting is the way that Israeli law and regulations allow you to control the speed of examination so that you can gain full advantage from the claims that you've had, you know you're going to get in other countries, and shouldn't have to argue over when it comes to Israel. And then finally, the meat and potatoes, time and cost. You know, time is money, and the amount of time it takes, whether it's sometimes having slowed it down or made it quicker, that has a price tag attached to it, normally savings, and using some of the tools that particularly Avram is going to relate to will enable you to save certainly significant costs. Again, whether it's for you as the entrepreneur, for the patentee, or whether it's you as the attorney on behalf of your client. So before we proceed now with my introduction, there are going to be a lot of numbers. I know I'm relating to the question as to why patent in Israel. As I said, it's very, very subjective. I just really would like to relate to two main things that we often take into account. And these two main things are represented by these, well, they look like mathematical expressions. They're not. An X really is an X, and a check mark really is a check mark. So what do these numbers represent? Let's have a look. 9 represents 9 million people, which is the size of the Israeli market, which is not big by anyone's standards. So that, generally speaking, is not going to be a reason why Israel is such an interesting patenting destination in certain cases. And I emphasize in certain cases. We'll see the patenting numbers in a couple of minutes. So what about the 20? Well, this takes us, yes, that's a 20, thank you. This takes us to the World Economic Forum. This is that forum that meets, I believe, in Davos once a year. And one of the things that they do is once a year they do a competitiveness survey of all the countries in the world. And they then produce a ranking, which of course is a very, very useful tool. And the question is, if you just think about what makes a country or anyone or any company competitive, there are a number of different factors that you might think of. One could be clearly innovation, which is what we're obviously here to talk about. It may be the availability of money, which would be venture capital. You can think of certain skills. There may be all the obvious factors that you would think of, and they group them all together. Here, these are the main ones. Possibly the most interesting one, which I think is often talked about, is the fact that entrepreneurial failure is okay. And that is something which is very much in the business culture of Israel. It's fine. You fall on your face. You scrape your knees, get up, dust yourself off, you try again. Some other cultures, if you fail once, that's it, you're done. In Israel, it's just encouraging you to carry on. So in the 2019 Global Competitiveness Ranking, Israel comes 20th, which is actually not bad at all. If you think, yes, of course, you have the usual, I was going to say culprits, but the usual candidates up all the way at the top. Above, you have the United States, Switzerland, Japan, Germany, you do UK down in 9th. For a country of Israel's size, with Israel's challenges, even without all of those, shall we say, handicaps, Israel is doing very well by all standards, which means that, yes, it's not going to be a primary patent destination, but it's certainly going to be among the secondary patent destinations. This is undoubtedly, at least in my mind, one of the reasons that some of the companies that file in Israel do in fact choose to file in Israel. So this is not a random slide with a bunch of logos that I just decided would look pretty. They do actually represent the companies from overseas, from outside of Israel, that are doing the most patent filings in Israel. And we'll see in a second how they divide down. Bunch of numbers. Okay, I'm not going to ask everyone to guess what these numbers represent. 2018 is the year, by the way, which is where these numbers come from. These are numbers generated by the Patent Office and appear in their 2018 report. You'll note that there are not that many applications overall, a little bit less than 7,500. A whopping 87% of them come from overseas. And they can really be divided down, not so much in 3 main fields as I've written here, but more 3 main groupings. And as you can see, the largest grouping, with some very well-known household names, broadly speaking, are in various fields of chemistry, medicine, and so on, human necessities, chemistry, metallurgy. This is obviously the lion's share of applications. I can say certainly this represents the largest number of applications that come through our firm in terms of Israeli filings coming from overseas. Maybe surprisingly small is 13% in those classified as physics. We know that Israel is a leader in various computer-related technologies and telecommunications, fintech. There are various fields which fit under this moniker of physics. 13% represents about 1,000 applications, if my mathematics is correct. And the remaining applications, you can see 22% to be a remainder is large. It represents a large number of fields in which there's a small amount of activity. It's certainly going to be agriculture and water technologies, various types of machinery, engineering. Anyway, so that's really the story with regard to the activity in Israel. I said I was not going to give you if you like, a solution to the mystery as to why is it that specific companies file in Israel. Clearly, you have certain cases where they see the activity that's going on, and they are planning to also to be active either in Israel or together with an Israeli company. And they want to make sure that they also have a handle on their own IP when it comes to Israel. Apart from that, it's really pretty subjective. So having said all of that by way of introduction, I now want to pass the baton over to Evyatar for an overview and something about software. So Evyatar, over to you.
Yep. Thank you, Jeremy. Good afternoon, good evening, good morning. As Jeremy said, my name is Evyatar Aaron. I'm a US and Israel licensed patent attorney here with JMB. And as mentioned, I'm going to briefly discuss the basic stages of application process here in Israel and give you an idea of what are some of the milestones you can expect throughout this process. And afterwards, as a bonus, I will be giving a brief overview of some of software-related patents also here in Israel. So the first thing is filing an application in Israel is pretty similar to how you would do it in many other countries. You can do it as a first filing, as a Paris Convention within the 1 year from the priority date, or as a PCT patent application. What is important to note here is that Israel is a 30-month jurisdiction, so the timing and paying attention to the dates is quite critical in that matter. What is needed for filing a patent application? As you can see, it's most of what is required in Israel is the same as what you would expect in any other country. One thing I would like to highlight is that filing the patent application, there are several possible examination requests which can expedite or slow down the examination procedure, such as modified examination, PPH, accelerated examination, and this will be discussed in greater detail during Abraham's presentation. Once the patent application has been filed, it's generally published within 18 months from the patent date, filing date, or the priority date. In the case of a PCT application, it is usually published within 45 days from the filing of the application in the national phase. Once the next stage afterwards is receiving what is known as a notice prior to examination. It's a procedural matter, sometimes referred to as a Section 18 here in Israel, referring to its number in the law. This notice is from the IPO requesting the applicant provide relevant art and background information that is relevant to patentability and what is known to the applicant. This includes also office actions and search reports received during examination of corresponding patent applications, say in other national phases, or an ISR of in the PCT, if that was not previously provided to the patent office during the filing of the application as a national phase. For those in the US practice, this is similar to the requirement of an IDS as far as duty of disclosure. One thing that is also interesting is notice prior to examination is a time when preliminary amendments can be filed for claims. So this is usually useful, for example, when amending treatment claims from a US format to comply with requirements of the Israeli law, something that will be discussed by Mike in his presentation. After filing a response to the notice prior to examination, the substantive examination of the application begins with mailing of an office action. And again, this is what you would expect from an office action. You have a period to respond, which in Israel is 4 months, which is a 4-month extendable date, with the option to extend for 4 months additional time, obviously with paying the necessary fees to the IPO. after all the examination has ended and the examiner is satisfied that there are no more grounds for rejecting or objecting to the application, a notice of allowance is mailed out, and the request to pay publication fees so that the application can be put in place for opposition. The window for filing an opposition here in Israel is 3 months. Very important to note is that it is a pre-grant opposition procedure, so there is no patent protection during the time of opposition or any opposition proceeding that is brought against the application by a third party. Once the opposition period expires and a patent is issued, all that is left to pay is pay the renewal fees, which are payable after 3 months of issuance, and they are usually paid for as listed below, as listed in the slide for those years in those groupings. And that pretty much is the basic application process portion of this presentation. And now on to something more relevant to some and interesting as far as patentability here in Israel regarding software patent inventions. In Israel, there is no section in the law that explicitly states that a software is not patentable. However, Section 3 of the law states that a product or process or the outcome of them must fall within the field of technology, which has been interpreted in case law as saying that computer programs, software, in and of itself is considered an abstract idea and therefore not patentable. However, the IPO has come out and stated that software-related inventions can be patented as an integral and essential part of a physical system, which is a pretty vague statement and not quite clear, but the way that it's being approached and interpreted here in Israel is that it follows the spirit of what the EPO has established as its standard for the patentability of software-related inventions. Specifically, you will need some kind of further technical effect of the interaction between the software and the hardware to get patent for software. Some quick examples of things that have been considered patentable here in Israel is methods of controlling an anti-lock braking system in a car, compressing digital video, encrypting electronic communications. So that's some general guidelines and that can be followed when considering what would be patentable and what is not. Obviously, this is very general and is meant to give a quick overview and not hardened rules as to how to approach and how to definitely patent a software, and it's usually dealt more as on a case-by-case basis. And just a final note in this matter is that in artificial intelligence, AI, related inventions are subject to the same guidelines as software-related inventions. So the test of whether it's patentable or not would be pretty much along the same lines as a software-related invention. And thank you.
So it needs to be connected to some kind of a physical system.
Generally, yes.
Okay.
That is what the Patent Office has established as one of the important requirements for getting software patented.
May I ask a question?
Jeremy, do we let questions now or shall we wait with them until the end? Unmute, please.
Yeah, if it's okay, we'll leave it till the end. I've started receiving questions, and after formal presentations, whoever wants to stay for the questions, we're happy to discuss any questions at that time for as long as people would like to discuss them. So that was it done, right?
Yes, yes.
Yeah, okay, so if you can wait till the end, that would be great. Great. So thank you very much, Evyatar. Mike, so now it's over to you. You can, for anyone that was a little bit bored by software and other techie type stuff, you can have your revenge with some bioclaims.
Thanks, Jeremy. Hello, everyone. Thank you very much for joining us from near and far. We definitely appreciate you sharing a little bit of your time today with us. My name is Mike Hammer. I head up the US and biotech practices here. I'm a partner here at JMB Davis Ben David. And consider the next few minutes something of a biotech interlude. So if Evyatar gave you a little bit of taste of some issues related to computer-related invention software, here are some issues with biotech. One of the questions which we most frequently get when an applicant from overseas, from outside of Israel, is entering the Israel national stage or is filing an Israel patent application is, how do my methods of treatment claims fit in with Israel patent practice? And the way that it works around here is that according to Israel patent law, methods of treatment of the human body are not patentable. It's interesting because the law is very specific and to say that it's the human body, which means that methods of treatment of a veterinary subject are perfectly patentable. But that's of course a very niche field. So your typical method of treatment, which you might have in a U.S. application, as I've put out here, a method of treatment of prostate cancer comprising administering to a subject in need thereof a composition comprising a compound of formula X. Perfectly plain vanilla method of treatment claim in the United States. You can't use that here. It's not patent eligible. It's not patentable. So in order for it to be patentable, it needs to be reformatted, rewritten as your typical composition for use, which is very common in the European Patent Office and in many jurisdictions around the world. And a very typical reformatting is presented here, which is a composition comprising a compound of formula X for use in treatment of prostate cancer in the subject. Pretty simple, pretty straightforward. A couple of notes about this. Many places around the world used to use the Swiss type format. And those of you who've been practicing for a few years, you know what I'm talking about. That also used to be usable here in Israel. It's no longer. If you're going to be entering a patent application in Israel with this type of claim, it has to be in the composition for use format. The next question that goes along with this is, well, if I've got these methods of treatment in my patent application, that's exactly the subject matter which I want to pursue, when should I make my amendments? And I would say that there are a few different options here, depending upon the goals of your goals and your client's goals. If the applicant knows exactly the types of claims they want, exactly the direction they want to head in, there's nothing to say that you shouldn't make those amendments at the time that you enter the Israel national phase, and we can make those amendments at the time of the application filing. And that is a common practice, to make those amendments, put those compositions for use primary in the listing of claims, and they're there for when examination begins. However, as Evyatar mentioned, the beginning of examination in Israel starts with the receipt of this notice prior to examination. And that is actually the longest period of wait between the time of the application filing and the receipt of this notice. Generally, it's the longest period of time that you wait. And it's during that time that many of our clients, their priorities might change, the direction that they want to take their technology, or the value of a particular piece of IP may change. Their priority for it may change. And so it's during that time that they may want to be thinking about other types of claim amendments they would want to do. And it's at this time, in the response to the notice prior to examination, that I actually think is usually the best time to make these amendments, both to reformat your claims from methods of treatment to compositions for use, but also it's the nice opportunity right before examination begins to reevaluate exactly where you want to take the application. Of course, if you don't do it at either of these cases, in either of these times during the process of examination, once you get an office action from the examiner and you still have methods of treatment in your claim set, you'll get a rejection under Section 7, and you can amend the claims at that point. A couple of other aspects to this, which Avram is going to touch on a little bit later, the specifics of both of these procedures, but they are directly relevant to methods of treatment. We've mentioned this a little bit here and there already, but in Israel, there's a procedure under the Israel Patent Law Section 17C, which we refer to as modified examination. And as Avraham will detail in a little bit, this allows a certain procedure that advances the examination of the application, but it requires identical claims from an already granted patent. You need to use those identical claims from the already granted patent in order to take advantage of examination under 17C. The problem is that the claims must be absolutely identical, so that claims that started their life and were granted in the US as a method of treatment and then have been reformatted as compositions for use don't qualify, because the Israel Patent Office has been very clear to say that those types of claims are not identical. In contrast, the patent prosecution highway procedure, which many of you are familiar with, I'm sure, doesn't have that kind of strictness attached to it. In order to take advantage of positive examination product from a corresponding patent office, and from the claims which correspond from Israel to those that have been either granted or have been nearly allowed in the other patent office, they only need to correspond to the claims together, the Israel claims and the overseas claims. And because they only have to correspond and not be identical, US treatment methods can be the basis for PPH, unlike what we were saying about modified examination. So that's my little interlude for you with biotech claims and methods of treatment in Israel patent practice. And thanks very much for your few minutes of attention. And I'll turn this back over to Jeremy.
Thank you very much, Mike. Everyone who is a non-bio person, I hope they've managed to get their coffee together and are ready to proceed to the beginning of the meat and potatoes, to the tools that Avram is going to share with us.
You can come back to the screen now.
I'm sorry?
Safe to come back now.
Yeah, safe to come back. Exactly. Anyway, so Avram, please take it away. How do we control the speed?
Okay, thanks, Jeremy. Thanks, Mike. My name is Avraham Hermon. I'm a partner at JMB Davis Ben David, and I've been with the firm since 2018. My specialties are pharmaceuticals and medical cannabis. That's generally what I deal with in the firm. I'm also a U.S. patent agent. So we're going to be talking about today changing the speed of examination in Israel. Sometimes you want to have an application prosecuted quickly. Sometimes you want to have one slowly. So first of all, what's the standard speed of prosecution in Israel? When do applications get picked up? So recently the Israeli Patent Office issued a report saying that they are generally picking up applications between 27 and 45 months of filing. And there's a breakdown in the report based on the examination divisions, and the divisions that examine applications in pharmaceuticals and chemistry are the fastest at the end of around 27 months. And mechanical inventions are what they call physics, are typically slower and are usually about 45 months. What's important to note is that divisional applications can cut the line and can get into, can be prosecuted quicker. The prosecution is picked up quicker and don't have the same weight of time. So some applicants are interested in slowing down, delaying the application. One reason to do this would be in order to wait until an equivalent patent in another jurisdiction is granted. So modified examination could be pursued. So one way technically to do this is just to respond to the request for information, which is the Section 18 request, which Abiatar had discussed, by delaying that response. Examination won't start until the response is received, which is usually 4 months after the response is requested. And you can delay this by 6 months with extension fees that aren't too expensive. Another way is to request a delay of examination, and you have to have a good reason to request that, and the Israeli Patent Office will grant a delay of examination by a year at a time, up to a year at a time. If an applicant wants to file a patent application and get prosecuting started quickly, so there are a few ways to do that. One way that we've done for a few of our clients is filing a priority document in Israel. So the applicant has to file a declaration where he says that this application is the first application on the invention. There can be no applications on the same invention filed in other jurisdictions. And also has to mention that there is an intent to file international applications based on this application. And for a small fee, this will cut the line of patent prosecution and patent examination, and the examiners will pick it up and issue a search report within 3 months. So this can be a very useful tool for companies, not only for Israeli companies, but also for overseas companies that are interested in a very quick search from an authorized search authority. This search can later be used for the PCT. If the claims remain the same, there can even be a discount given on the subsequent PCT that's filed. Since we have a bunch of people on the call that are from the US, I will mention that US inventors that invent something inside the US are required to receive a foreign filing license before filing outside of the US. So generally that's done pretty much automatically. When an applicant in the US files the US application, he's granted within a short period of time a foreign filing license. If a US applicant were to file in Israel first, he would need to actually send the patent application to the patent office, petition them to give a foreign filing receipt, and this is generally should be granted quickly, and then can proceed to filing the priority document in Israel. Another way to make prosecution go quicker is to enter the national phase before the 30-month deadline. And that would be because the Israeli Patent Office works on a first in, first examined type of system. So as you get into the Israeli Patent Office quicker, you'll be examined quicker. Once your application examination has started, there are petitions that you can file to speed it up as well. One has to do with green inventions. And green invention, the rules that were put in place for green inventions were originally put in place for environmentally friendly type inventions. But in April, the Patent Office came out with a special order that allowed applicants who had COVID-19 related inventions for treatment or prevention of COVID-19 to use the same pathways free of charge, and it allows a search report also within a short period of time, about 3 months. We've used this for one of our clients who has an invention which was filed shortly before this came into place, and then when it came into place, it was we filed a petition, and we're going to have it examined soon. Another way to speed up the examination is through PPH, the Patent Prosecution Highway, and as Mike has mentioned, presenting similar claims to the Israeli Patent Office that were allowed in other jurisdictions. There's also Section 17, which was also mentioned before, which is some applicants decide that they have a patent with claims that they're happy with in another jurisdiction. And Section 17C essentially says you could take that granted patent, has to be granted patent, not allowed, granted. Take those claims in one of these jurisdictions listed here on this slide and file a request for 17C, and then the examiner will allow based on the granted claims. Keep in mind that the examiner has a right to reject claims. This is not a guarantee. If you have a patent in Canada or in the US or Germany or Australia, you're not guaranteed a patent in Israel. And just as an aside, this in the pharmaceutical and bio fields, this will happen generally more often. An examiner. So this is a list of 17C type countries, and this is a possibility, and we provide the service for a lot of our clients to streamline prosecution in Israel. That's about all I have to say on this topic. Thank you for listening and for participating from wherever you are in the world.
Yes. Thank you, everyone, for that. I will proceed directly to the finish line with getting back to my slideshow. Here we are. A minute. Okay. So over to Eviatar has been and gone. What we really need to get to here, we have some more numbers. I promised numbers, and I started with them, and I'm going to finish with them. These are maybe slightly more interesting. So it's very, very easy to see that, okay, as I say, this is time and cost. We have costs going down, being halved. We have time going down. What are we actually talking about? So here's the story. There are really three types of examination referred to. One is the normal type of examination where you just let things happen, let things go along as they do. You know, in the same way that the average number of children in a family is not point anything. It's an average is a statistical value. So here too, this average sort of cost, this is actually taken from a number of life science cases. So in any case, so normal examination will roughly take 7 years, roughly cost $9,500 from filing to grant. That's what we're talking about. The big difference comes when you apply for modified examination, also known as Avram said as Section 17C, and then you're really cutting out any significant prosecution. The main cost component in obtaining any patent is the legal work, is the patent attorney work. And here, all we're essentially doing is saying, here we receive these claims in another qualifying jurisdiction, often going to be the US, but could be Europe, could be Japan. There are a number of other qualifying jurisdictions. And when we do that, as you can see, we slash the costs, we slash the time. The final thing, which certainly in terms of time is very effective, is that we also accelerate using PPH. This may also work using other types of acceleration, but particularly when we're using PPH, that has been done time and time again. We have seen it since it became possible to do. It doesn't reduce costs by very much more. There's not very much more by which they can be reduced, but it will speed things up. And as Avram said, the only type of case in which that won't work is where the examiner says, well, hold on a second, that it's all very well that you received allowance somewhere else, but we think there are some other issues we need to deal with. They will treat it using an accelerated process, but the modified examination there will go out the window. It's in the minority of cases, but that also gives a certain sense of security from the point of view that this is not a rubber stamp, but it's a real process. Okay, I see actually, I'm getting a question here which I'm going to answer out of turn because it relates specifically to this. Phil Summer. Okay, you ask, is the $9,500 based on already drafted application? The answer is yes. Okay, this does not include drafting. This is for an application that you have drafted, you have filed in the US or, again, another qualifying jurisdiction, and you have received, I'm sorry, you haven't necessarily filed it anywhere else, but the $9,500 does not include drafting. Okay, Phil, if you want to go back to that afterwards, then during discussion when everyone's mic is going to be on, we'll certainly be able to do that. So this is really the end, I believe. We need to have the legal disclaimer. I'm not going to read it, and I'm not sure whether anyone else is going to bother, but it's there. These materials will be distributed probably tomorrow as well, so you should just know, again, any specific issues need specific questions and specific consideration. Okay, we're going to get back to, I see Phil, you put up an additional supplementary question or statement. But before that happens, I'm going to actually stop screen sharing so we can all see each other. There we are. And I want to thank everyone for joining us. As I said, we're not asking anyone to leave now. In fact, the more people stay, the better. But you have spent a chunk of your day with us. I hope that you've learned something. Obviously, if you decide to stay around for the questions, even better. This is like the fun part of things. I'll just finish with one thing connected to the time of year, and again maybe to the period, because it's very, very difficult not to relate to the period at all. I was talking to my 93-year-old mother a few days ago, and she was saying everything's about the corona. I said, what are you talking about? She said, look at the newspaper. I said, well, there must be something that doesn't mention corona. And I looked at the first page, the second page, every single article had something to do with it. So I will relate to it briefly as well, but on this maybe slightly more upbeat level. We're getting close to the Jewish New Year. It's a couple of months away. So, and the Jewish New Year is a time when we, right, thanks. That's a time when we sort of look back on the previous year, and most often we say, that was a terrible year. Let's throw out all the bad and let's just embrace, all the goodness of the new year. One of the things that I feel isn't stressed enough is that however bad the previous year was, there's always a lot of good in it. And the situation that we're in at the moment, for sure, there's a lot about it which is truly tragic, has been tragic to thousands or millions of families the world over. The only qualifying feature or characteristic anyone needs to have is to walk on two legs. And it's affected almost every single society and millions of people the world over. Because of that, we've had to find, we again, as human society, have had to find solutions and workarounds. Zoom coming into its own has certainly been one of them. And I think that while a lot of the bad stuff, 10, 20 years down the road, hopefully sooner, will be in a way forgotten and put behind us, the advances that we have actually seen during this time and the positive adaptions, hopefully, I believe they will be with us for a long time, and will say that, yes, this was a terrible period, but there were a number of, shall we say, pieces of light that actually shone through we can take with us. So again, my wish to everyone is that moving forward, we continue to create, we continue to do all the things not that just that we were good at beforehand, but things that have come out in terms of mutual help, many positive initiatives that we've seen develop. They should go forward. All the bad stuff should hopefully be forgotten. Anyway, that's what I have to say, shall we say, wrapping up. I'd like to now move to the questions. Oh, and just answering one other question and that is that we will be making the recording available as well as the materials. That might take a day or two, but they will all be available. They'll be sent out. The recording will be on our YouTube channel as well. And whoever has to leave now, well, even if you don't need to leave now, we hope to see everyone at future events. And obviously, anyone who wants to talk about anything, anytime, you know where and how to find us. On to the questions. So I had a number here, and I'm going to take them in order. Okay, so Teresa, you know, let me open mics, just because I have to see how I open them now. Let me see, 1 second. Unmute all. Okay. Just a request, as everyone's mic is unmuted, if anyone finds that they have some background noise, you know, kids or drilling or whatever, if they can mute themselves, that would be appreciated. Anyway, so Teresa, you still here?
Yes, I am.
Okay. So you asked about the question of provisional patenting in Israel.
I'm not able to hear me too well.
I'm sorry? Teresa?
Oh, go ahead. Sorry,
Yes.
go ahead. Go ahead, yes.
That is a subject that has been receiving a lot of attention recently. It doesn't yet exist, but there is a proposal to introduce provisional patents. There are a lot of details that need to be worked out. At the moment, it's open to essentially public comment. There have been and are going to be some meetings with concerned parties, mainly with the patent attorney and legal community. We will, once we know exactly what's going to happen and when it's going to happen, we'll obviously make details available. At the moment, though, we're not quite there. The normal, you know, if you ask a patent attorney about provisional patents, there are a number of points that normally come up. Again, based on experience in the US, is it good? Is it bad? Is it something that is doing possibly well, saving money to the applicant, providing a disservice because he or she is deciding that because claims are not required, they can draft them however they want, they'll get a number and that's good enough. Then again, we know you can actually file a shopping list for your groceries, and if you pay the fee and you fill in the forms, you'll still get a number. So all these questions have come up in debate. And we'll see. The feeling is, or it seems that the Israeli Patent Office, it does not want to do a carbon copy of the US system. There's been some, I think the main departure is the possibility, and again, at the moment it's only a possibility, of being able to take a provisional and converting it into a full, which in the States would be utility, into a full application, not as a separate application, but really as part of the same process. Whether that will be accepted and how it will work, you know, it remains to be seen. It's probably not a very satisfactory answer, but that's the only answer that I can give at the moment because we ain't there yet.
Thank you, Jeremy.
You're welcome. Okay, so, right. Pat, Patricia, how do you prefer to be referred to? Pat?
I usually go by Pat.
Okay, right. It's shorter anyway.
Yeah.
Okay, so you actually asked a number of questions about other types of IP rights, which I think, you know, as as professionals dealing normally with the IP of our clients, as opposed to simply this or that patent, I think it's well worth relating to. You asked about designs. You asked about treaties in general. First of all, Israel is a party to the Hague Treaty, but I have not. I'm not actually sure whether we have implemented yet. I know that all the infrastructure is there to implement. I have not actually seen any Hague registrations which designate Israel. Evyatar, do you have anything to say about that?
No, I haven't seen any of those yet either, though I know that it's in the works to try and get it going, get it off the ground.
Right, right.
As priority goes, you do have a 6-month window to file from other countries a design application here in Israel.
Right.
Giving priority to a previous design, which is...
That goes back to... There was actually a new law introduced in 2017 with a number of changes. And one of the new features of that law is providing I believe was a 2-year period of unregistered protection. Anyway, so there are certain similarities between the new design law and design laws, say in the States, Europe, and so on. But we actually have a summary of that on the website. If you're interested, we can certainly make that available. In terms of trademarks, Madrid, I would say that most registrations in Israel these days do go through Madrid. There are many that don't, but Madrid is certainly an option. And of course, I'm sure as well known to everyone, unless there are problems with the Madrid registration in Israel, you do not require local representation. Having said that, my understanding is that there are normally problems created by the trademark office.
Right. In the U.S., they just implemented a law where you have to have a U.S. licensed attorney if you are a foreign filer, regardless. Which was good for me, but I actually got some clients who got stuck in the middle of that, international clients. But yeah, it's a little territorial about it. The question also for, do you recommend that people apply in both Hebrew and in their native language for trademarks for protection?
That all depends how you're going to use it. If you're going to be using it separately in Hebrew and in English, they're separate marks.
Right. They don't, okay.
In China, for example.
Right.
The difference is normally, because Israel is a fairly simple phonetic language, there's only going to be one way of spelling it, and it's only going to sound one way. Whereas I know that in China, it could be probably not an infinite number of ways, but it's a lot more complicated there. Okay, so you say, right, so Phil, getting back to PPH. Yes, in Israel as well, when you are filing PPH, it makes things quicker, but it's not a home run by any means. They still have to search. What we have found, though, by experience, is that in a similar way to when we request Section 17C on modified examination, they will relate to the foreign examination as having satisfied all the requirements, and it will go very, very quickly, which is so a PPH will normally produce a good result. It certainly doesn't hurt to request 17C at the same time. But again, even 17C, as I mentioned before, it's not a rubber stamp, and they will look at the examination as done in the parallel jurisdiction. And if they find additional art that was cited, if they find additional art that was not cited, but they think is equally or more relevant than that which was cited, then they will refuse the request for modified examination. Or if they feel that the art that was cited was not dealt with properly by the examiner, then there too they are allowed to be not convinced by the examiner's allowance. So generally speaking, in the various biofields or life science fields, you probably get about maybe as much as a third of all requests for modified examination which are rejected. In other fields, mechanical and various fields of engineering, that drops to maybe 15% that are rejected. So it's worthwhile trying, but you have to know that it won't necessarily work. There is also another twist in this particular tale, which was introduced in February of this year, and that is that if you have not originally asked for modified examination and the examiner cites art as against novelty or inventive step, you cannot then simply file a request for modified examination and that's it. You have to file the arguments, or you have to file some arguments, some justification as to why your claims overcome the cited art. So even within the context of modified examination, that was introduced into the rules in February, and one can ask them, well, what's the point? But I'm not going to go into that right now. But we just need to know that's there. The truth is, it's not.
Jeremy, I would just actually add one point to that, which is what we've been doing with exactly that type of a situation. It's not that the full arguments about each and every reference that we've replicated the full arguments that were presented in the corresponding jurisdiction, but that we relate in some way how the documents which were cited, in the Israel Patent Office were also, whatever the Israeli examiner is talking about is taken care of by the amendments and as it was related to in the corresponding jurisdiction. So it's kind of a hybrid between a full response that you might have to prepare if you'd never seen those documents before, and what's much more a classical modified examination, which is we're requesting modified examination, take these claims and allow them. So it winds up being somewhere in between.
Right. Okay, so let's put that behind us. Sandro, you asked the following question. My client has a patent pending in several jurisdictions in Latin America, and it is related to a piece of equipment used in the mining industry. Would you recommend patenting this item in Israel? This is a sort of question, Sandro, that I would definitely, if it were my client, I would discuss with them and I'd say, well, what is the need to patent this in Israel? What will it give them? This really goes back to the discussion beforehand. The question is, how developed are companies in Israel who your client would view either as being potential purchasers of his invention or potential infringers, which are actually really one and the same. So there is some sort of mining that goes on in Israel. The natural resources that Israel has are actually mainly under the Mediterranean. They're very large gas and oil fields, but it really is very, very, very much case specific. So
okay.
Sorry.
I I appreciate it. I appreciate your opinion, Jeremy. When I initially started representing this client, he was already set up in the U.S. here, and he had a very strong presence in Latin America because it's a very strong mining region.
Mm-hmm.
After that, we have an office in Madrid, so we were able to get him set up in the EU. And as Philip Suma very wisely suggested a few minutes ago, he indicated or suggested Australia, which they're also very strong. And I brought this up with him, but his response was, I'm not really all that interested, but I have heard there are some advantages to Israel. And to be honest with you, being Jewish, I was kind of steering him in the Israeli direction more than the Australian one. So it's not the best legal advice I guess I could have given him, but it's my personal advice to him. And he was interested, which is why when I saw this webinar coming up, I said I have to be on it to see the pros and cons. But I think I still feel that Israel is a strong option for us. I think it's going to establish a stronger presence for him in terms of patents that he already has when the time comes for him to sell his company. Would you agree with that?
Again, it's very, very case specific. I wholeheartedly go with Phil's advice to file in Australia. I mean, simply because, you know, from general knowledge, back from geography in high school, you know, everyone knows that there's a huge mining industry in various parts of Australia. In Israel, again, there's not a lot of mining that's done here. There is the only mining that I think actually is the, I don't know, do they still mine copper down in the mountains north of Eilat? Possibly. Although it's possible that those mines were last tapped several thousand years ago. But it is entirely possible that there are companies that develop mining equipment clearly before export. And in terms of, shall we say, pure business advice, it really, I think that as far as I can see, the main justification would be if there are companies that, again, that already develop this type of machinery. If you want, we can obviously talk about this more sort of offline.
Sure.
In general terms, that's what I would say. Again,
thank you.
Getting back to the very broad statistics that I brought before. I mean, I'm not even sure they reach the level of being statistics, but the general numbers that would fall into all the others, which are like 22%, and all the other areas are bits and pieces. So anyway, that's again, I'll be happy to continue that conversation offline.
Thank you, appreciate it.
Welcome. Phil, yes, I'm just going through the comments here. Yeah, if you file a US application as a skeleton, don't expect priority for starting a weightlifter later on. Absolutely. I think that, I hope that we all know that, but sometimes it's most obvious things that need to be restated, which of course is, again, one of the reasons that we as patent attorneys don't like provisionals when drafted by the inventor, because they normally are lightweight. They try to take them seriously, but they don't know enough to be able to, the things to be concerned about.
If I could comment, obviously this is not a lay audience. This is an expert audience. So I didn't mean to imply that anybody in this group wouldn't recognize that. One of the things you can do if you're not, a number of you are in the United States, what I always tell associates from outside the United States is that our provisional system is rather liberal, and our continuation practice is extremely liberal, more than any country in the world. And so I'll give you an example of a filing scheme. In the US, you might start with a provisional, and then you can file 3 or 4 provisionals as the provisional year moves forward. And so depending upon what prior art came up later or all the rest, you'd have several quote unquote priority dates, not in the official sense, but you would have these intermediate dates as against the prior art. The other thing our easy continuation practice allows me to do is to file, get my foreign filing licenses, as it was either Mike or Avram pointed out, get your foreign filing license, and then immediately file in a country. I use countries that speak the English language because languages were not my skill set, and so I'll use one of the English language speaking countries in which accelerating examination is very easy. So if I have to wait about 90 days to get my foreign filing license and then put it on file in one of these countries, I can get a first office action from a first world examiner in English in about, within about 5 or 6 months of my original filing date. And then if I can prosecute that to allowance, I can immediately take the PPH application or the PPH petition to the United States. Now, if I give up subject matter to do that, the easy continuing system in the United States allows me to just file a continuing application for maybe the broader scope or better scope or different scope that I gave up when I simplified my original application for PPH purposes. So that's worked out very well with the proviso that you have to pay the freight in the foreign country, especially if you're serious about your claim language.
Mm-hmm. Thanks, Phil. That sounds like good advice. And I'm not sure that we've actually, maybe my colleagues will have something to add here, but I'm not sure that we've necessarily done exactly that. Actually, one thing that I think Avram has done on a number of occasions is to use the accelerated system in Israel to get early allowance. And then, of course, that really opens up your options for when you go overseas.
Right, exactly.
Okay, I have one more question here from Israel. This is not from the country, but Israel Jimenez. I hope I pronounced his surname correctly. Israel? I see you're still here, but I don't hear you. I don't actually.
It's okay, Jeremy. Israel.
Oh, there you are. Yeah, you're right in front of me.
Yeah.
Okay, so you asked when you advised to file a divisional patent application in Israel. Well, there are going to be a number of circumstances. First of all, if we get a restriction requirement, then that's going to be a clear indication that we can either, as in other countries, we can either argue it, or we can say, okay, you've asked me to restrict, and then maybe at the same time, I can see a clear path to getting allowance for one of the inventions, one of the claimed inventions, could be by using modified and/or PPH. And then I'll say, thank you very much, grab that with both hands, and file a divisional for the rest. There was a short time for a couple of years in Israel where you couldn't have, where patent applications couldn't have grandchildren. In other words, you couldn't file divisionals or divisionals. That is actually one of the rare cases. No one has asked about litigation, but this is one of the rare cases where there was some litigation actually against the patent office saying that was unfair. And then that practice was changed, it was dropped. So in Israel, you can have divisionals or divisionals. So essentially, if you have X number of inventions, claimed inventions in your parent application, you can keep on dividing that down until, basically until you get to the end. Quite clearly, there are going to be different, I would say, tactical questions as to, if you have 3 or 4 inventions, whether you're going to file, take the one and then file 3 more divisionals, or file all of them in one divisional and then and then see what happens with that. You know, clearly those are going to be tactical questions that you're going to deal with at the time. That's basically it. You pretty much, as in every other place, you file it when it makes good sense because you're going to achieve some of your goals. And you know, we all know that clients will often approach this question as, well, sort of, you know, I want to argue here. You know, it's not fair. You know, how dare the examiner say that we're talking about more than one invention? And you know, of course, we know they can argue and they can pay a lot of money. They may not get anywhere. So we have to sometimes save them from themselves. Guys, anyone want to add anything? No?
I'll add that in the United States, you can have more descendants than are listed in the entire book of Genesis. And it is sometimes a practice in the United States to keep an application pending just as one more continuation so as to capture subject matter that your competitor might bring to bear in an effort to design around. So that's another, you know, there's no limit whatsoever. And depending on the case, it can get expensive. But I've had up to 10 just to try and keep something on file while an important commercial product was in the market.
Can I add something here?
Sure.
Sometimes it pays to keep an application pending, and rather than to forward it to try to get issued, because the pending application can be more powerful than a patent. Because if you sue on a patent, the claims are open to attack. If you, on the other hand, write a letter to a competitor when the application is pending and say to the competitor's attorneys, my client is going to come after you once that patent issues, the competitor can't do anything because the patent hasn't issued. It's just a threat. When the patent issues, if your client says to you, tell that son of a gun to stop, and you caution him that may propel him into an expensive patent litigation, you'll be asked to say, well, offer him a license. And in the US, unless that's very carefully worded, the defendant or the putative defendant could be in a position to come back and start a lawsuit to attack the threat. So it's a very dicey situation. But if your application is pending, you have a lot more flexibility. And the issue comes down is what to the client is, what is the competitive market doing to the client? If this product that's competitive is simply just entering the marketplace, a threat letter should be sufficient. But if it's been out there and it's doing damage to the marketplace, that's a different story.
Spoken like someone who's been around the block a few times. Thank you, Phil. Okay, we have another question. This is from Daniel Lee, correct? Okay.
Yes, correct. Thank you.
Right. I think you're asking about filing a PCT application through the Israel Patent Office?
No, it's you said a PCT will be coming up, an Israeli PCT or something like that.
The National Phase, the Shlav Leumi?
No, you mentioned something of a local PCT or something, or provisional.
Yeah, I mentioned, yes, I mentioned about a provisional.
Apologize.
No, that's okay. They're discussing introducing a system which is similar to the US provisional system. It hasn't yet been introduced, and once it is, we'll have to see whether it makes sense, whether we'll start advising clients that is a valuable, that's a good way to go. I expect that, as with the US provisional, it can be a valuable tool if it's used properly. So that's really what I would say there.
Thank you very much.
You're welcome, Daniel.
Thank you for all this session.
Our pleasure. Our pleasure. I gather you're fairly close by, somewhere in Jerusalem, correct?
Yes, correct.
Good. Okay.
Yeah, we've met in your offices with a previous project.
Okay.
But yes.
Great.
Thank you.
Great. So I think that pretty much brings this this session to an end. Thank you, everyone, for showing up. I know there were some people that couldn't make it till a bit later, so thank you for joining. And
Good seeing you.
Good seeing you as well. Again, this is a great thing about Zoom, that we meet at Inter, and unless we've scheduled a meeting, what are the chances of running into each other? I know normally when you don't schedule, you do bump into people, but this is, I would definitely prefer Inter, but this is in the present circumstances, this is a pretty good alternative. And I mean, Phil Summer, I think the last time I saw you was probably about 2012, if I'm not mistaken.
Parker Poe.
Right. Down in Atlanta, I think.
Right.
Right. So it's good to see old friends, new friends, and we'll have to do this again sometime. Rest assured that when we do, you'll hear about it. And we'll invite you to join us. We'll see what we have to discuss. And thank you everyone for joining us. Have a good morning, good afternoon, good evening, good night, and just stay healthy and well and safe.
Thank you.
You too, Jeremy. Thanks so much.
Thanks for coming.
Bye, everyone.
Bye.
Thank you very much.
Bye.
Bye, everyone.